Eloisa owns a residential lot in Cebu. However, her title indicates that she is married to her former live-in partner in that title. Eloisa is asking if she can go to the Register of Deeds and request for the correction in the title, as she was never married to him anyway. Will a mere letter request suffice, or should she need to submit an affidavit too? Eloisa, a mere letter or affidavit will not suffice because a court order is needed to correct a land title's entry. Section 108 of Presidential Decree 1529 states, no erasure, alteration, or amendment shall be made upon the registration book after the entry of a certificate of title or of a memorandum thereon and the attestation of the same by the Register of Deeds, except by order of the proper court of first instance. A registered owner or other person having an interest in registered property, or in proper cases, the Register of Deeds with the approval of the Commissioner of Land Registration may apply by petition to the court upon the ground that the registered interests of any description, whether vested, contingent, expectant, or inchoate, appearing on the certificate have terminated and ceased, or that new interests not appearing upon the certificate have arisen or been created, or that an omission or error was made in entering a certificate or any memorandum thereon, or on any duplicate certificate, or that the same or any person on the certificate has been changed, or that the registered owner has married, or if registered as married, that the marriage has been terminated and no right or interests of heirs or creditors will thereby be affected, or that a corporation which owned registered land has been dissolved has not convened the same within the 3 years after its dissolution, or upon any other reasonable ground, and the court may hear and determine the petition after notice to all parties in interest, and may order the entry or cancellation of a new certificate, the entry or cancellation of a memorandum upon a certificate, or grant any other relief upon such terms and conditions, requiring security or bond if necessary, as it may consider proper. Provided, however, that this section shall not be construed to give the court authority to reopen the judgment or decree of registration, and that nothing shall be done or ordered by the court which shall impair the title or other interest of a purchaser holding a certificate for value and in good faith, or his heirs and assigns without his or their written concern or consent where the owner's duplicate certificate is not presented. A similar petition may be filed as provided in the preceding sections of the law. It states that all petitions or motions filed under that section, as well as under any other provision of the decree after original registration, shall be filed and entitled in the original case in which the decree or registration was entered. Be reminded that our opinion is based solely on the information you provided us, and it may change depending on any additional information. You are free to consult a lawyer of your choice regarding your legal concerns. Email us at ptvbatas@gmail.com. Attorney JJ Jimeno Atienza for the Rule of Law.